Thank you, Madam Chair. Thank you all for being here. And Mr. Guffey, I appreciate your advocacy and want to express my condolence for the loss of your son. I can't imagine the trauma that you and your family have been through. But I appreciate your taking that trauma and using it to protect other families. I have not had a chance as a new member of the Senate to really study the multiple approaches of the various bills, although some I've supported in the House. But I wanted to ask you, Professor, we established Section 230 for the reasons I think you implied, which is it was a nascent industry. They urged us to do so that we would not stifle innovation. They also made the argument that without 230, they would not moderate content because they would be sued if they did, and this would encourage them to moderate content. Well, there may have been a time where they moderated content, but those days seem to be over. It certainly wasn't enacted because it was believed necessary for the First Amendment. First Amendment stands on its own 2 feet. In the absence of 230, companies could still plead a First Amendment defense to any case. What is your preferred approach? That is it a repeal of 230? Is it changing it from an immunity to some form of defense? Is it to cabin 230 in some way by narrowing the scope? What are the merits of the various approaches?
Thank you, Senator. I would say that it's important to, a couple of things. I would say that there was discussion in the deep background about this free internet nascent industry. And when we look at the policies and the findings at the beginning of Section 230 of the Communications Decency Act, there is languages to that. But I would repeat, the overwhelming background and discussion was about the child protection piece. And therefore, I think that the concern, I think that better than repealing the entire thing is to keep the C2 language, which gives a cover, gives a protection to a platform if they do, and specifically, if they remove anything they consider to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. That will protect them. That's all they need. They do not need C1, which is what has been turned into this de facto near absolute immunity. I think also adding the state's ability to proceed is an important thing. I think outside of 230 is holding them liable when they host this material, like that's has been discussed at length as well. So I think that those and some of the other things that I've listed, but I don't want to use up too much of your time, all work together to respond to the complex crime.
And counsel, in your representation of clients in this area, what do you believe would be most helpful in terms of making sure that you can get the discovery you need and that that we have established the right protections and the right burdens in terms of the platforms and the pipelines?
Thank you. I agree. We are long overdue to just abolish Section 230. But what's important is that clients need to get into discovery so that they can actually know the extent of the problem. And the only way we can do that is if the standard is reasonable for parents to plead. If we have to show that the company knew about that picture or that exact victim, that exact perpetrator, there's no way a client's going to be able to overcome a motion to dismiss and get into discovery. So we need to actually have standards like negligence, which the law already affords in almost all causes of action.
So let me ask this question. I don't think there's any doubt that if the companies devoted their technological capability to trying to solve this problem, that they could make enormous gains. They wouldn't be able to eliminate the problem altogether, but nonetheless, they could prove very effective. What would you propose the new standard be then? That is, if it's not going to be possible to completely do away with this, the standard can't be perfection. How would you define the standard of care that you would expect the industry to follow given that it hasn't had to follow any standard with the protections of 230.
And if you could just quickly answer
Oh,
that.
sure. Well, these are products, so strict liability should apply here. If these companies have created a defective product, then all users should be able to sue them without having to even prove a duty if the product injured them.